The criminal appeal. Come with me, and I'm going to tell you some tricks and secrets about your criminal appeal. Let's say you've gone through trial, and the jury has ruled against you, and you've been convicted of a crime in California. If it's a felony, you have 60 days in which to file a notice of appeal to notify the court that you are not in agreement with the conviction and that you want to appeal it to a higher court. The 60-day period is generally jurisdictional, meaning if you file it on the 61st day, you will not be able to appeal. The appeal is not a new trial. Everything that happened in the trial will be part of the appeal, and a copy of it will be sent to the Court of Appeals. For example, all of the transcripts, which contain all of the witnesses' testimony, all of the attorney's arguments, all the attorney's opening and closing, the attorney's voir dire of the jury. That has all been transcribed, and it will be sent to the Court of Appeals, along with the clerk's transcript, which is all of the documentary evidence, the minute orders of the court's rulings, the exhibits that were used in the trial against you and for you. They will all be sent to the Court of Appeal, and the Court of Appeal will review it to determine if any errors have been made and to determine if your constitutional rights have been violated. We're currently involved in a criminal appeal, and we did not do the trial court case. The trial court case was done by an attorney who did an excellent job, and on review of the case and on review of speaking to people who witnessed the trial as it went along, it's hard for us to imagine that this defendant should have been convicted based upon the evidence that was presented by the district attorney and the Los Angeles Police Department. We're in the middle of that appeal. We will get hopefully a ruling within the next month or two, but remember, it is not a new trial. It's to show the Court of Appeal that legal mistakes were made during the trial, either by the judge through the rulings or by the district attorney and what he or she did in trying to convict the defendants, and it's a review of any constitutional arguments that the defendant may have. Let me tell you a quick story. Several years ago, a family came to us and wanted us to do an appeal because their son had lost a criminal trial and had been sentenced to several years in state prison. They were under the impression that I'd be going to court and arguing the case again in front of the same judge. But when I explained to them that it's not a new trial and it goes to a higher court in front of 3 different judges, they wanted to know, well, how can these judges make this decision on the appeal if they weren't there in court watching the trial? And the way that's done in California is the court reporter's record and the clerk's transcript of the record is sent to the Court of Appeals, and they read everything. And then the appellant, which would be us, we would file a brief on behalf of the defendant in the Court of Appeals. The people, or the district attorney's office, would file a responsive brief to the conviction and the appeal, and then we would have a chance to file a reply brief, and then we would go to court and we can argue the appeal in front of the 3 justices on the Court of Appeals panel that was assigned to the case. The parents were very confused and surprised that I wasn't able to call new witnesses for their son, because apparently there were witnesses that weren't presented by the defense attorney at the time of trial. But I told them that couldn't happen on appeal. I did tell them in certain instances they may be able to ask for a new trial based upon that, but they didn't want to proceed in that matter, and we just proceeded on the appeal, which is just based upon the record of what happened in the trial court. If you have any questions about appeals, please give me a call at 888-888-6582, or check us out on the web at the address below. Also, you can download a copy of our book and my special report about handling criminal matters.
The next email you receive will contain a video on how to select an attorney. For your free consultation, call the law offices of Vincent W. Davis and Associates today. 1-888-888 1-888-888-6582. That's 1-888-888-6582. Thank you for watching.